principle of proportionality is one of the cornerstones of modern law, political philosophy, and international relations. At its core, proportionality means that state actions, whether in restricting individual rights, enforcing criminal sanctions, or waging armed conflict, must be balanced, measured, and justified. It is both a legal doctrine and a moral standard, demanding that the means used to pursue legitimate ends do not exceed what is necessary and reasonable. Today, proportionality operates across multiple fields: constitutional law, human rights law, administrative law, international humanitarian law, and criminal justice. Its importance lies in providing a safeguard against arbitrary power and ensuring that justice is not only done, but also seen to be done. This essay explores the principle of proportionality in depth, its origins, its legal dimensions, its role in criminal and international law, its interpretation in human rights courts, and the debates that surround it. Historical and philosophical origins. The roots of proportionality can be traced to classical philosophy. Aristotle, in his Nicomachean Ethics, emphasized moderation and the golden mean in justice, an idea closely linked to proportionality. Roman law also reflected proportional ideas in the principle of sum cuique tribuere, to give each his due. In the medieval era, proportionality appeared in the doctrine of just war, articulated by Thomas Aquinas, who argued that force must be used in a measured way and only to the extent necessary to restore peace. During the Enlightenment, Cesare Beccaria, in On Crimes and Punishments, 1764, argued that punishments must be proportionate to crimes, not excessively cruel or arbitrary. This principle profoundly influenced modern criminal law. By the 19th and 20th centuries, proportionality became embedded in constitutional systems, especially in Germany, where the Verhältnismäßigkeitsprincip, principle of proportionality, emerged in administrative and constitutional law. It was later absorbed into European Union law and international human rights jurisprudence. Proportionality in constitutional and administrative law. In constitutional law, proportionality ensures that restrictions on fundamental rights are justified. Courts often apply a 3- or 4-step test of proportionality. 1. Legitimate aim. The state measure must pursue a legitimate goal, such as public safety or national security. 2. Suitability. The measure must be capable of achieving that aim. 3. Necessity. No less restrictive means should exist to achieve the same goal. 4. Proportionality, stricto sensu. The measure's benefits must outweigh the harm it causes to rights. This test has become a universal framework in constitutional adjudication. For instance, the German Federal Constitutional Court has repeatedly used it to balance freedom of expression against public order concerns. Similarly, the European Court of Human Rights, ECTHR, employs proportionality when evaluating restrictions under the European Convention on Human Rights. For example, in Handyside v. United Kingdom, 1976, the ECTHR held that restrictions on freedom of expression must be necessary in a democratic society, a formula grounded in proportionality reasoning. Proportionality in criminal law. In criminal law, proportionality relates to both substantive and procedural justice. Substantively, punishment should correspond to the severity of the crime. This principle rejects both excessive penalties for minor crimes and leniency for serious ones. For example, life imprisonment for petty theft would be disproportionate, while only a minor fine for murder would also violate proportionality. Procedurally, proportionality limits the use of investigative and coercive powers by the state. Police searches, detentions, and surveillance must not go beyond what is necessary to achieve legitimate law enforcement purposes. Courts regularly strike down laws or practices that overreach in the name of security. Proportionality also connects to sentencing guidelines and international human rights standards, such as the prohibition of cruel, inhuman, or degrading punishment under Article 7 of the International Covenant on Civil and Political Rights, ICCPR. Proportionality in international humanitarian law, IHL. In the context of armed conflict, proportionality is a key principle of international humanitarian law, especially in the Geneva Conventions and their additional protocols. Here, proportionality means that even if a military target is legitimate, the harm to civilians and civilian objects must not be excessive in relation to the anticipated military advantage. For example, bombing a military installation located in a densely populated area may violate the principle of proportionality if civilian casualties and damage far outweigh the military gain. This principle has been applied in international tribunals, such as the International Criminal Tribunal for the former Yugoslavia, ICTY. In the Prosecutor vs. Kupreshkic case, 2000, the ICTY emphasized that indiscriminate attacks causing excessive civilian harm constitute war crimes. Proportionality in human rights law. Human rights law is perhaps where proportionality has had its most significant development. Courts and monitoring bodies use proportionality to balance competing rights and interests. For example, the right to privacy versus national security surveillance, the right to free speech versus the protection of reputation, the right to freedom of religion versus the rights of others in a pluralistic society. The European Court of Human Rights and the Inter-American Court of Human Rights both employ proportionality analysis to assess whether limitations on rights are justified. The UN Human Rights Committee also refers to proportionality when interpreting the ICCPR. Proportionality ensures that states do not invoke vague or sweeping justifications, such as public interest or national security, without showing that restrictions are narrowly tailored and minimally invasive. Criticism and debates. Despite its importance, proportionality is not free from criticism. Several debates surround its use. 1. Judicial activism versus restraint. Critics argue that proportionality grants judges excessive discretion, effectively allowing them to substitute their own policy preferences for those of legislatures. Proponents respond that proportionality provides structured reasoning that enhances transparency. 2. Indeterminacy. Some scholars argue proportionality is too vague to provide clear legal outcomes. Different judges may weigh competing interests differently, leading to unpredictability. 3. Cultural relativity. Proportionality may reflect Western liberal values and may not align perfectly with legal traditions in other regions. Nonetheless, it has increasingly been accepted as a universal legal standard. 4. Application in war. In IHL, proportionality assessments are extremely difficult, as military advantage and civilian harm cannot always be quantified with certainty. This has led to controversies in conflicts involving drone strikes, aerial bombardments, and urban warfare. Case studies. R.V. Oakes, 1986, Canada. The Supreme Court of Canada established a proportionality test under the Canadian Charter of Rights and Freedoms, requiring that restrictions on rights must be reasonable and demonstrably justified. Handyside v. UK, 1976. The ECTHR upheld restrictions on obscene publications, but stressed that limitations must be strictly necessary and proportionate. Kupreshkic case, ICTY, 2000. Confirmed proportionality as a binding rule of international humanitarian law. Aharon Barak's jurisprudence in Israel. The Israeli Supreme Court, under Barak, developed proportionality as a central method of constitutional adjudication, balancing security needs with human rights. Conclusion. The principle of proportionality represents one of the most important tools in modern legal reasoning. From criminal sentencing to freedom of speech, from police powers to the conduct of war, proportionality provides a structured framework for balancing competing interests. Its flexibility allows adaptation to diverse contexts, but this very flexibility also invites debate about its indeterminacy and potential misuse. Ultimately, proportionality acts as a safeguard against excess, whether of government power, punishment, or military action. It embodies the ideal that justice must be measured, balanced, and humane. While challenges remain in applying it consistently, proportionality remains indispensable in the pursuit of rule of law, human dignity, and democratic governance. Sources 1. Alexei R. 2002, A Theory of Constitutional Rights, Oxford University Press. 2. Barak A. 2012, Proportionality, Constitutional Rights, and Their Limitations, Cambridge University Press. 3. Beccaria C. 1764-1995, On Crimes and Punishments, Cambridge University Press. 4. Cohen Elia M. and Porat I. 2010, American Balancing and German Proportionality, The Historical Origins, International Journal of Constitutional Law, 8-2, 263-286. 5. Gardam J. 2004, Necessity, Proportionality, and the Use of Force by States, Cambridge University Press. 6. International Criminal Tribunal for the former Yugoslavia, ICTY, Prosecutor vs. Kupreshkic, Judgment 2000. 7. European Court of Human Rights, Handyside v. United Kingdom, 1976. 8. Supreme Court of Canada, R.V. Oakes, 1986, 1 SCR 103.